One thing that attorneys do not take nearly as seriously as they should are default judgments. A default judgment, generally speaking, is what you go and you get when the other side doesn't take the time, energy, or the effort to answer the lawsuit. Now, that's a pre-answer default judgment, meaning that the defendant doesn't even take the time to give an answer. There's also another kind of default judgment that's a post-answer default judgment that has requirements that are a lot stricter and harder to meet, and you have to be even more careful with. And a lot of times, even experienced practitioners that are used to taking the traditional default judgment, a pre-answer default judgment, can still mess up when they try to take a post-answer default judgment. I'm not going to really talk about post-answer default judgments in this particular video. So if that's the situation you're in, then you should probably find some information elsewhere, even though a lot of the same things do apply. The main reason why you should be very afraid and concerned and anxious when you take a default judgment is that there's so many ways to mess it up. And the only time you're going to find out that you messed it up is years down the road when you're trying to collect on the judgment. And generally speaking, you'll find yourself in a position where you'd be able to collect on the judgment, except you made a mistake way back at the beginning because you didn't take it as seriously as you should. The only time that it really comes up as an issue is after somebody does decide that it's a serious issue, when you're trying to collect your judgment, when you've frozen their bank accounts or whatever it is you're doing to try to collect the judgment, and then they go out and hire a lawyer that goes through and studies your work and grades your homework. And if you made a mistake, then you could cost yourself and your client however much money you would have otherwise been entitled to under the default judgment. Just because someone doesn't show up right now and you go into court feeling like, oh, it's easy, I'm going to win, I'm the only attorney showing up, I'm the only side showing up, at some point they are going to care. If you're taking money, if you're taking property, if you're taking something of value from them that's serious enough, they're going to find a lawyer. And they're going to find a lawyer that's used to these, and they're going to go through your homework with a fine-tooth comb, and if you've made a mistake, they're going to find it. Generally speaking, appeals in the state of Texas and elsewhere, there are presumptions in favor of the party that won. It's generally speaking easier to hold on to a judgment once you get it. And that's not the case with default judgments. With default judgments, they're very strictly construed. It is studied very carefully. There are absolutely no presumptions in favor of the default judgment being legitimate. A lot of times attorneys, I see them and they're upset when a judge doesn't give them a default judgment for whatever reason. Some, in their mind at the time, minor technical problem or something that's not really that big a deal. And the reality is, generally speaking, the judge is doing them a favor. The judge is giving them an opportunity to go back, do it right the second time, instead of finding out that they made a mistake 3 years later, which is an embarrassing nightmare to have to tell your client, oh, you know what, I got the guy's name wrong. It turns out that there was a P in there that we didn't put in, or, it wasn't something LLC, it was something LP. And, I didn't really check at the time, but this other attorney did, and he called me on it, and now I'm stuck. That's not anything you want to have happen. If a judge ever rejects your default judgment, don't get mad at the judge, just go back and do it right. Some things that you should look at, and don't, by the way, rely on the judge to fix your mistake, because there's a very good chance that the judge isn't going to. Judges are busy. There's a lot going on. You're presenting an order to them, which presumably you've looked over, you've studied it. Even though a lot of judges will sometimes take a look at it, look for the common mistakes, there's a lot of ways to go wrong. And so if a judge signs it and then you get your judgment because there's no one else showing up and you came in thinking it was going to be easy because you were the only one, you're going to find out the hard way down the road. Some things that you need to look for: spellings. It's amazing how many people mess up spellings. Juniors, seniors, English has some tricky spellings. Letters are silent. It's worth the time to go through, make sure you get it absolutely right. In the case of suing entities like LLCs, corporations, things like that, a mistake that's very commonly made is not having the service match up with the petition. And the main way that can happen is a lot of times you'll be serving someone in their capacity as a president. A real common way that this comes up is you're suing both an entity and also the president of that entity. It doesn't have to be a big entity. The president might be one of 2 or 3 members of an LLC, depending on the situation. And so you're just serving them both at the same time. Well, most process servers are in the habit of just putting down registered agent. So your petition is going to say president, your return of service is going to say registered agent as opposed to president. And for that reason, it can get overthrown. It's got to be absolutely perfect. And it's something that you don't really think of. You just want to get the judge's signature and move on. But it really is worth the time to kind of slow down, take a look, make sure you do it right. The other way that things can go wrong is serving the agent, whether it's a registered agent, president of the corporation, other officer that you could serve under the Texas Code of Civil Procedure. You serve the agent instead of the company. It'll say, by serving John Smith, president of this corporation. Well, it should say serving this corporation by and through its president, John Smith. And it really feels like a big nothing. It's nothing you'd really notice if you don't know what you're looking for. But there have been millions of dollars go one way or the other based on these types of mistakes more than once. There's a whole bunch of case law out there, just well over 100 cases. And that means in each and every case, somebody made a mistake and an appellate court had to review it and decide whether or not it was a big enough or a serious enough mistake to cost them the default judgment that they could have had if they just did it right the first time. And more often than not, they throw it out because, like I mentioned before, there are no presumptions in favor of the service being correct. Another thing, even if you do technically get a default judgment that stands up, the other thing that you really need to look at, really need to study, really need to do a little thinking beforehand as far as trying to figure out what the future is going to hold. And when you try to get money for your clients, what's going to come up is making sure that it'll provide the protection that you need and you want in a bankruptcy. Because a lot of people, if you've got a big enough judgment, there's a good chance that either someone's going to declare bankruptcy or they're going to be forced into bankruptcy by you. Now, you can force them into bankruptcy, you can get a receiver, there's a lot of different ways. But very often, if you're taking all of somebody's money, they're going to wind up in bankruptcy. It's not a very controversial statement. So some of the things to look at is, do I have a cause of action that is dischargeable in bankruptcy? Because there's some causes of action that if the creditor objects, they're not dischargeable in bankruptcy. And the two really big, really common ones you'll get are fraud and violation of a fiduciary duty. Now, what's interesting and what's tricky and what catches a lot of attorneys, and it's a mistake they generally only make once, especially if it's a big enough case, is that the federal courts do not just take the state courts, and particularly Texas's word, on what constitutes fraud. You've got to have very specific language in your order that you don't need technically for your state court order, but in order for it to maintain its status as non-dischargeable in bankruptcy, it has to be in there. So you've got to go back and you've got to, at the time that you're taking your default judgment, make sure that you're thinking about what's going to happen if there's a future bankruptcy proceeding. Am I going to make sure that all of the language in there, it's not particularly tricky, it's not particularly complicated? You just have to do it right. And you have to realize that if you're dealing with a default judgment, if you're concerned about dischargeability, you have to make sure that you include the federal language, even though it's a state case. Another thing to be aware of is the fact that child support is generally speaking non-dischargeable. That's another reason why family law cases are typically very good cases to get a receiver on, because someone can declare bankruptcy and, well, if it's a state court case that involves child support, it's not going to be dischargeable. So even after the bankruptcy, the person's still going to owe child support and the receiver or the collections attorney is not going to go away. Ultimately, the important thing is make sure you do it right. And if you don't know how to do it right, that's all right. But find somebody that does.